The University of Connecticut Co-op Bookstore, a place where readers and authors meet. My name is George Cole, Professor of Political Science Emeritus, and it's my pleasure to introduce our speaker, Professor David Yeloff, and to join with you in celebrating the publication of his book, Pursuit of Justices, Presidential Politics and the Selection of Supreme Court Nominees. David Yeloff received his PhD from Johns Hopkins University in 1997 and his Juris Doctorate from the University of Virginia Law School in 1991. He joined the University of Connecticut faculty as assistant professor in 1997. Pursuit of Justices is based on Professor Yeloff's PhD dissertation, which was awarded the American Presidency Prize for 1998 by the Center for Presidential Studies at the George Bush School of Government and Public Service of Texas A&M University. It also received honorable mention for the 1998 Edwin S. Corwin Prize for the best dissertation in public law, given by the American Political Science Association. The book deals with one of the most crucial powers of American presidents, the nomination of justices to the Supreme Court. While much public and scholarly attention has focused on the Senate confirmation process, Yeloff asks, how do presidents decide who they will nominate? The book examines presidential politics and the selection of Supreme Court nominees by 7 presidents, from Truman through to Reagan. In an epilogue, he makes some initial observations about the nomination politics of the Bush and Clinton presidencies. Professor Yeloff will speak on the pursuit of justices. Following his presentation, he will be pleased to answer your questions.
Thank you, George. Thank you, everybody, for coming. This is a topic I've been spending a lot of time on for a very long time, and I guess I thought I'd start with a question that graduate students like to ask, that other professors like to ask, which is, how did you get interested in this in the first place? And my interest in the selection of Supreme Court nominees dates back at least 12 years, before graduate school, before law school. It was the summer of 1987 or so when I was working as a reporter for the St. Louis Post-Dispatch in their Washington, D.C. bureau. And during the summer, it was some Monday morning I came in around 10 a.m. Things generally don't happen at the newspaper till 11 or noon. But I had a bunch of pretty seasoned reporters come up to me and say, Lewis Powell just resigned from the Supreme Court. You've got to get down to the D.C. circuit. You got to start reading everything that Bork's written in the last 6 years. Now, this is unfortunately before Lexis was commonplace in most newsrooms, and so that's what I did. I went down there and read through a lot of very, very not scintillating administrative law opinions. There was the next day I came in, and they said, your work paid off. Bork was just nominated. Go to the Hill and find out what the top congressmen think of him. And so I did that, and I was there when Senator Kennedy told us that Robert Bork's America would be an America of back alley abortions and segregated lunch counters, and I was there when Biden explained that he wasn't sure that his campaign for the presidency was just getting going, and he wanted to really take a look much closer at the issue, and at Orrin Hatch, who explained that anybody who rejected Robert Bork for the court was just plain political. And I thought that was interesting, but I think what was surreal about those 2 days, and they really were surreal, was I had the distinct feeling that I'd kind of walked in on the final act of a play, You know, and that didn't really change. My feeling that I'd kind of come in at the end didn't change 2.5 months later when Robert Bork was rejected by the Senate. And that's simply because I didn't know how we got to where I started, in that sense of why had Bork been chosen? Why had Reagan, President Reagan, decided that this should be the next nominee for the court? And for that matter, when had he been chosen? There had only been 24 hours that had passed between Powell's resignation and Bork being chosen. And most newspapers, including our own, just echoed the basic administration line, which was he was tapped because he was a true conservative. And I guess I was never satisfied by that explanation, simply because it struck me there were other conservatives. Why this particular conservative at this particular time? And this wasn't an isolated example of this phenomenon. The initial stage of Supreme Court nominations, as George suggested, I'm talking, of course, about the stage where the nominee is actually chosen before he's confirmed. That usually flies below the radar screen when we're talking about scholarship and political science analysis, unless there's some confirmation controversy. You know, unless a nominee runs into trouble in the Senate, our interest in Supreme Court appointments tends to diminish. I don't think it should strike anybody as surprising that when you ask the American public who are the Supreme Court justices you know the most about, most first name Clarence Thomas. And very high on the list is often Robert Bork, who's not even a Supreme Court justice. So I think that should tell us something about where our interest generally lies. And even when appointments run into trouble, the focus is never on how did this nomination come about in the first place. The focus is on how did the president screw this up. They didn't lobby hard enough, or they just didn't sell it to the public well enough. We hear that a lot. And lost in the shuffle is the whole political decision-making process that produced this nominee in the first place. And I found that that is the determinative process in most cases. I mean, in this century, 89% of all nominees to the court by the president have been confirmed. And even in the most recent era, you know, the modern era, when we're told that things have changed, 12 of the last 14 nominees have been confirmed. And so my interest in this topic is about how is that first choice being made, the choice which is, to a large extent, a critical one. Now, there are a number of factors that influence how a president chooses a nominee to the court. I obviously have them in the book and go on about them. You know, the personality and predispositions of the president himself is obviously a critical factor and should not be underestimated. Maybe even the dominant consideration, what the president's personality was, what his likes or dislikes were. Dwight Eisenhower, for example, despised politicians like Franklin Delano Roosevelt, who he believed routinely reneged on promises after making them whenever it was politically expedient to do so. And so when Chief Justice Fred Vinson unexpectedly died at the age of 63 in 1953, Eisenhower was presented with a dilemma. He had promised Earl Warren, the governor of California, that the first vacancy during my administration will go to you. Never mind the fact that he never would have imagined that that would be the Chief Justiceship. And never mind further the fact that Earl Warren, who had never served even a day as a night court judge, or a night as a night court judge, I should say, in Eisenhower's mind, seemed particularly ill-suited for the position as the leader of the nation's highest tribunal of law. But Eisenhower stuck to his promise, a promise that Earl Warren, in political expediency, made sure he knew that he planned to suggest that he live up to it. And to that extent, Eisenhower's personality as somebody to stick with that kind of promise, loyalty first, politics second, at least in this particular circumstance, that produced the Chief Justice, obviously, for the next 16 years. Lyndon Johnson's personality, obviously, was also a dominant consideration. He decided in 1965 to name his best friend in the world, Abe Fortas, to the Supreme Court, and he was going to name him to the court even though Fortas didn't want to go to the court, even though Fortas told him on several occasions, I don't want to be nominated, I respectfully decline. He appointed him to the court virtually against his will, and that was a large product of Lyndon Johnson's personality. By contrast, the other side of that coin, I guess, is Richard Nixon, who made it very clear he wanted to appoint justices who he did not know. That was kind of a very important criterion to him. He told G. Harold Carswell, who he had nominated to the court in 1970, that you're never going to see me again socially. We don't know each other. It's an interesting start for a relationship between the executive and judicial branches. And there was no question that he did not know William Rehnquist, another appointment of his, very well, because he referred to the young Justice Department official on more than one occasion as Wrenchberg, which I guess the clear implication is close friends these two men were not. And Nixon was obsessed with confounding his enemies. He really hated the Ivy Leaguers, and he wanted to stick it to the Ivy Leaguers whenever possible, and thus Warren Burger was the perfect justice, a graduate of St. Paul College of Law. He thought that would stick it to the Ivy Leaguers, and he didn't back down from that. So I don't mean in any way to imply that the personality of the presidents is not a very, very important consideration. But in the course of writing this book, what I detected also is that there are some patterns and some trends of nominee selection that cut across presidencies. And some of these patterns, I think, provide a pretty good indication not only as to why certain nominees were chosen, but also how what should have been a comprehensive selection process could produce on more than one occasion, how do we be charitable about this, flawed nominees. One noteworthy pattern of selection concerns what I call the shift to criteria-driven appointments. By that I mean the establishment and application of multiple political filters to identify prospective justices. Any prospective justice has to fit through this particular filter in order to be considered. And of course, each interest or each political requirement becomes a filter that the candidate must survive. Sounds reasonable, except of course for the fact that a very rigid adherence to certain filters is going to stifle the process tremendously, is going to pigeonhole the president, possibly into doing something that he didn't want to do, and worst of all, eliminate a lot of very qualified candidates at the outset, long before any opinions have even been reviewed. The classic example of this is President Eisenhower, who in 1956 was looking for the following. He wanted to nominate to the Supreme Court somebody who was a state judge, a Catholic, a Democrat, in his 50s, preferably from a state that he needed to win in the upcoming presidential election. Now, each of those filters traced itself to a specific political interest. The National Council of State Chief Justices had made it very clear to him that they had not had a state judge make the Supreme Court since Benjamin Cardozo, and they expected it was about time. The Cardinal Spellman and the Catholic interest groups made it very clear that Frank Murphy had been the last Catholic justice. He had died in 1949. It had been 7 years, and let's get to it. The Democrat was part of the Eisenhower mystique. He truly wanted to show the American public that he was above politics. He constantly railed on the Roosevelt and the Truman administrations for their highly patronistic decisions, making choices simply to make friends and cronies happy. And so he was going to rise above it all and choose a Democrat. Could there be anything more bipartisan to that? And he was going to do it magically 2 months before the upcoming presidential election, in case there was any doubt about that. Now, who is going to fit all of those many political filters? And the answer was one person, William Brennan, a young New Jersey justice. Probably the only one in the country who could fit the bill. I did some research. I tried to find, was there anybody else? I found somebody who was 60. Ooh, not in his 50s, wouldn't work. This is the kind of process, though, that the Eisenhower administration went through. And it produced William Brennan, who, you know, from many accounts, is a fine justice. It's not so much the product as much as how you get to the product that it becomes almost a matter of luck, lucking out into a good justice rather than searching, vetting, and choosing a fine justice for the Supreme Court. The following year, 1957, Eisenhower's criteria changed a little. Now, he wanted a Republican, a federal court of appeals judge, also in his 50s, but he wanted somebody this time from the Midwest. This produced a list of 4 names. which included Charles Whittaker, probably the least distinguished justice in the history of the Supreme Court, and that's being charitable. Whittaker emerged from that list because he had very good friends in very high places. I think the frustrating aspect of this is why limit yourself to that list? And political filters and criteria-driven selection processes were a dominant feature of the Eisenhower administration and of some future administrations. The two very sorry moments early in the Nixon presidency, the nominations, ill-fated nominations of Clement Haynsworth and G. Harold Carswell to the Supreme Court, both of those were a product not only of bad judgments by the Attorney General, John Mitchell, but also both of those names emerged out of a very elite pool indeed. And I use the word elite in quotes. These had to be Federal Circuit judges, Republicans, in their 50s from the South. Well, the problem you have here is that you're just coming off 8 years of the Johnson and Kennedy administration appointing judges. There just weren't many Federal Circuit judges from the South who were Republican. And a lot of people say, how could you choose that kind of individual? That was the only people. Individuals such as that were the only ones left who could survive the many filters that the Nixon administration imposed. I guess what I'm suggesting is certainly it is preferable to establish some guidelines for Supreme Court recruitment. But I think if the criteria becomes overly restrictive, it may force the selection outcomes down to their lowest common denominator. Sometimes the lowest common denominator is not very low. Other times, it's exceedingly low. And I think it was the Nixon administration, the Eisenhower administration, and to some extent the Reagan administration got themselves into trouble, all using these kinds of highly restrictive filters early on in the process. Another defining characteristic of this process that I want to talk about today is the increased reliance by presidents on advisors, but not just one advisor, in many cases multiple advisors. These advisors are, of course, to aid them in their various Supreme Court recruitment efforts. But what's happened is that in recent times, this has sometimes meant multiple officials engaging in, and I mean this, the exact same vetting and consideration and selection exercises, each of them with their own direct line to the president. How does this work? Well, it began during the Nixon administration when President Nixon was very frustrated, to be honest with you, with the analysis and with the consideration techniques of his Attorney General, John Mitchell. These inadequacies, he believed, had led directly to the ill-fated nominations of Haynsworth and Carswell, and he'd led the president down some very faulty paths. So at 1971, Nixon said, this time it will be different. I'm going to have other advisors advise me. And he brought in several other advisors, John Ehrlichman, David Young, John Dean, who we know from some events that would come about 2 or 3 years later. But what was interesting about it is he didn't replace Mitchell. He didn't even bump Mitchell upstairs. This was not the classic, this football coach is not winning, we need to try something else. He left Mitchell in place as the Attorney General to continue to engage in all the consideration and selection processes that he had been engaging in before, but now he was going to have other people doing the exact same thing. They won't communicate to each other, but this will reduce the possibility that we could end up with somebody with some mysterious problem or flaw. Multiple advisors, overlapping responsibilities. Now, this same thing was employed by Ronald Reagan decades later, the following decade really, when he was frustrated by some of Edwin Meese's decisions, and so he had Howard Baker, A.B. Culverhouse, and others use their own bureaucracies, their own consideration processes, their own selection bureaucracies at work, dedicating themselves to the process. Here's the problem. Organizational theorists, Anthony Downs, March, and Olson, all agree that duplicate functions can have very negative consequences on the process. By that I mean competition. Suddenly, the role of advisor shifts to the role of advocate, because you are not the only person who is going to get the president's ear on this particular circumstance, and you may not even know what's going on with the other advisors, kind of a prisoner's dilemma, if you will. And so what happens is they will, in effect, shift to advocating what their bureaucracies or their particular agendas demand that they want, and the president's own interests, the president's direct goals, may get lost a little bit in the shuffle. This kind of competition also leads to other problems. Information corruption. I mean, if you're Edwin Meese and you want Robert Bork to be named to the Supreme Court, you're not going to make it very clear that there are some problems with nominating him, because if you do, you're going to lose. Howard Baker's going to get his nominee. Might be different if I'd get my second-place nominee, but this kind of information corruption pervaded the Reagan administration, especially in the second term. He was not getting, the president was, all the information he needed because his advisors had a specific interest to not give it all to him. And this kind of information corruption did undermine presidential interest in the case of the Reagan administration, but I think not so surprisingly. Same thing happened with Nixon. Nixon, and some of us recall this, had a very, very, very bad time in November of 1971 when he announced, or it was leaked to the press, that he was planning to appoint Herschel Friday and Mildred Lilly to the United States Supreme Court. Now, if you are as dumbfounded by those names as many people are today, it's not, you know, it's very understandable. These were not distinguished names in the law. These are the names that the competition within the Nixon administration had produced. And no wonder that Herschel Friday, a fellow bond lawyer from Arkansas, who John Mitchell knew very well, no wonder that John Mitchell wasn't eager to make sure that the president knew all of his flaws, all of his problems, all of the various objections that could be made to him. Same thing happened to some degree in the Ford administration when the Attorney General found himself, Edward Levy, unnecessarily rushed into decisions that weren't necessarily the decisions he would have made if he had had the time to consider the problem a little more carefully without the onrush of other advisors. And of course this did happen with Ronald Reagan, who appointed O'Connor and Bork to the Supreme Court without having the time to digest significant information that actually I learned was in the hands of advisors but never actually got to the president himself. The question about O'Connor was about her views on abortion. Nobody knew quite where she stood on abortion. And the truth was, one of the Attorney General's assistants had made a call to Sandra Day O'Connor the day before her nomination, asked very, very specifically, let me know what you think about these various issues. Asked her about events in her past. The assistant to the Attorney General, then William French Smith, wrote everything down. A wonderful memo. Anyone who'd read that memo knew that O'Connor was a very big question mark on abortion issues. The information from that memo never got, as far as I can tell, to President Reagan, except for the fact that William French Smith made it very clear to Reagan, she's where we want. She's where we want her to be. Was it true? I don't know. I can say this much, President Reagan didn't really make that decision. By the way, the assistant to William French Smith, somebody you may have heard of, Ken Starr was his name. So we've heard Ken Starr, we've heard John Dean. Very tough to keep impeachment, I guess, away from Supreme Court recruitment. What do we make of all this? Hard to say. A lot of the mistakes that were made by presidents, I believe, resulted from presidents fighting the previous wars. A war had been engaged in an administration that president wasn't even a part of. Presidents come to office, they know what their predecessors did, they know what their predecessors did wrong, and they're so desperate to avoid repeating those mistakes that what often ends up happening is they go down even more troublesome paths to disaster. Truman, as I already said, had a reputation of appointing his friends, his cronies. You don't get on the Supreme Court during the Truman administration unless you play poker with Harry Truman, and that was the case. Clark Clifford was very disappointed. He thought that maybe he'd won too much, and that they didn't want to let him leave to go to the court because he wouldn't be around to win it back. Whatever it was, Eisenhower came to office determined to do the opposite. I'm going to appoint people who all have judicial experience. It's not a bad idea except for the fact that he's working with a very slim pool, because at that point, I guess you're talking about close to 20 years of Democratic presidents appointing mostly Democrats to courts of appeals. Not going to be a heck of a lot to choose from. And that's what Eisenhower ran into right away. John Marshall Harlan, his second appointment to the court, was a federal appeals judge. What most people don't realize is he'd been an appeals judge for 9 months. The Attorney General, Herbert Brownell, said, we got to get you on the appeals court because that way we can get you on the Supreme Court. Kind of a bizarre way to run a Supreme Court recruitment business. Same problem with Nixon. Nixon followed the Fortas affair, when Abe Fortas had been accused of advising President Johnson directly while he was on the Supreme Court. And so, as I said, Nixon was determined to only appoint individuals that he didn't know at all. But of course, by not knowing them at all, he also didn't know anything about their flaws, their problems. He didn't realize that G. Harold Carswell had given a rambunctious speech to the Ku Klux Klan in the 1940s, explaining that white was the superior race. Maybe if they were friends, that would have come up. The bottom line is, we're talking about individuals who nobody in the administration knew anything about because they believed that was important. Something gets lost in the process when you are so obsessed with avoiding the mistakes made by your predecessors. And Gerald Ford took this to a different level. He followed Nixon. Now it was important to have the most qualified nominees of all, but how many nominees are there going to be that every single person agrees is qualified? That's going to be a limited pool too, and as we've learned in recent years, it's not always going to produce the most interesting justices in the world. John Paul Stevens turned out to have, and continues to have, a remarkably interesting and some would argue superlative career on the Supreme Court. But at the time, he was a little-known justice from the Seventh Circuit who, to a large extent, his big benefit was nobody knew enough bad things about him. And it's not so much that that's a bad criteria, it's when that becomes the dominant criterion that presidents run into problems. I guess in summarizing, because we are almost out of time, modern presidents have a lot of advantages in choosing Supreme Court justices that older presidents did not have. A World Wide Web and an internet can give you instantly every single opinion that this person wrote, probably every speech that the person gave. It's very hard to let a lot sneak by a president. A huge bureaucracy is available of experts, high-level, intelligent lawyers who can research every opinion and come up with every possible objection imaginable. And yet, despite all of these advantages, presidents, it seems, continue to hamper themselves. They continue to hamper themselves with ineffective selection mechanisms that undermine their own goals and their own agendas. It's tough to say at this point whether presidents since Reagan have avoided those difficulties. Bush and Clinton, it's very, very clear, were obsessed with avoiding the Bork problem. They were obsessed with choosing justices who wouldn't cause confirmation problems. Now, I know that goes against what you think because Clarence Thomas was an appointment of George Bush. But the decision to appoint Clarence Thomas was driven, no question about it, by confirmation. There was a belief that there was no way that the Democrats would stand in the way of an African-American nominee. He wanted to put them in that confirmation difficulty, the puzzle, if you will. It didn't work out, as we know, although he did survive long enough to make the Supreme Court. Will the future presidents, whether it's George W. Bush or Gore or Bradley or whoever, will they avoid these problems? Will they understand that all of these advantages that they have need to be harnessed? That information can be corrupted, it's obviously too early to tell. But the lessons of the past are there. I hope they take some of them to heart. And I thank you for coming. I've been told that if people have questions, I can try to answer them. I don't know if people do. John.
So, President Gale, how would you select Supreme Court nominees?
Well, you know, I'm really just good at looking. Of course, I would also have to survive the constitutional challenge because I'm not 35 yet. But, you know, I think that the model probably is a combination of the Kennedy and the Eisenhower experience, taking away the rigid criteria. The model being one very competent, well-suited advisor to head up the bureaucracy that will do the selections. Herbert Brownell clearly had agendas, but it's very clear in watching him, or I'm not watching him personally, but seeing through the papers and by interviewing him exactly how he did it, that he felt some sense of accountability. He was the only one advising President Eisenhower during the administration. In fact, several individuals wanted to give their suggestions to Eisenhower, and Eisenhower always said, talk to Brownell. which is a very different way of going about it, obviously, than we see in future administrations. That sense of accountability meant something to Brownell. He felt that if it was a bad appointment, it would sit with him, not just with President Eisenhower. And so I think the first step is to entrust one person, okay, with the ability to make mistakes, but more importantly, the ability to step up to the plate and provide, hopefully, less filtered, less corrupt information, because you will be accountable. It's not simply a competitive situation. I think there also should be some sense of the politics of the situation, the environment, driving what we're looking for as president, rather than a host of political decisions that have been made well before the process. You know, there was an obsession with picking somebody who would feel the right way on abortion and school prayer, and that produced Robert Bork. That obsession that produced Bork took place long before the Democrats had taken office, taken the Senate back in 1986. So Bork might have been a fine candidate for the Reagan administration in 1983, or in 1985, or even in 1986. But by 1987, the filters, the criteria that had driven his nomination no longer made much sense. I guess what I'm asking then for is what I would do, or hope that a president would do, is the opposite of what maybe some instincts say, and that is entrust one competent person with the process so that it can be somewhat centralized, that he can serve as a clearinghouse for the president, and then the second step, not adhering to criteria so early that by the time the nomination is actually made, your criteria make the decision look overtly political. It's very hard to see criteria-driven appointments like Brennan and Whitaker as anything more than going down a checklist and fulfilling some kind of political needs. So that would be kind of the beginning of the process. Chris.
I have a question. I don't know if you can answer it directly, but you ended by saying hopefully they'll be able to avoid, you know, what the trouble they've gotten into, which raises a question for me about motivation in terms of the president, him or herself. Especially in studying the results of maybe a bungled appointment or nomination, or a justice that turns out to be not so competent, is there anything within the process that would motivate a president, especially a president that may only be serving one term, to do a good job as you've just sort of framed it?
You know, it's a great question. How much of the immediate political environment can be positively affected by the president to rebound or redound to his best interests? And what about the legacy? You know, I mean, sadly, the historical legacy of Eisenhower is not just about what he did in the Cold War or what he did in various other domestic issues. It's also that he left us with a lot of lost opportunities, a lot of justices, Minton, Burton, and I'm sorry, not Minton and Burton, Whitaker, individuals who really were not up to what he wanted, or Warren and Brennan, individuals who were very qualified but not in the ideological direction he wanted. I mean, you ask a very interesting question, and I think that that's maybe the ultimate problem with making nominee selection at the top of the priority list. If you make a great, if you produce a terrific nominee, and I think some have argued that that's what Clinton's legacy might be, that his only two nominees are, by most accounts, very highly qualified, able justices, you're not going to create tremendous political benefit for yourself. I mean, to some extent, it's like, good, that's what you're supposed to do. And in that sense, I think what you may or may not be suggesting, but I think it's true, is that the Supreme Court appointment process is a minefield. I mean, it's very important that you not screw up, because if you screw up, we'll remember you for that. But if you do the right thing, we won't remember you for it. And so, you know, I think it's the ultimate puzzle of the process. The best justices we won't even know about. Probably till long after the president is gone. In the case of Roosevelt, the great accomplishments of Hugo Black and William Douglas and others were long after President Roosevelt had died. So given that, unless there is some hereafter, I think it's hard to find that kind of political benefit. It's a good point. Bob?
Dave, can you speak to the disconnect, or what seems to be a disconnect for those of us who look at the court, between the selection process for Supreme Court justices and down the hierarchy to the appellate and district court level? And I know it's beyond your scope a bit, but your scope is large.
Well, I think that obviously the traditional focus of lower court judges, and I think you're particularly talking about district court judges and court of appeals judges. The traditional focus was making senators happy. To a large extent, the circuit courts and the district courts, especially the district courts, were the place where senators, particularly senators from the president's own party, had their say to a large extent. And I think you can find that in the selections that presidents have made, you know, going way back. The D.C. Circuit is obviously the exception, where there are no senators, and I think it's interesting to watch how D.C. Circuit appointments compare to Supreme Court appointments, because in a way, the D.C. Circuit is an opportunity. You can choose somebody irrelevant of whether they're good friends with a senator or are in good stead with a senator. You can choose them for that reason, see how they do. I mean, maybe they're a future Supreme Court justice. Maybe they're a heck of a good D.C. Circuit judge. I'm sorry. And so to that extent, I think the D.C. Circuit almost has to be put aside as a different ball of wax, if you will. In terms of the overall difference, I think some presidents, I give Ronald Reagan a lot of credit in that regard, but I think to some extent Nixon saw it too, understand the opportunity that the lower court provide for them, that a tremendous difference can be made in the jurisprudence and in the law of this country based on what you do at the lower court level, and that the Supreme Court is in that sense much more incremental because they only hear 70 cases a year, et cetera, et cetera. And so I think that to some extent the lower courts and the interest in the lower courts will always be a product of the president personally, and whether, you know, not just whether the president's a lawyer, whether the person has interest in the law per se, but whether he sees the lower courts as part of his overall political agenda, as Reagan clearly did, as Nixon clearly did. I think that one of the complaints about Bill Clinton we often hear is that he doesn't understand what the lower courts can mean in terms of changing the law of this country. He's only had 2 Supreme Court justices, but he's had obviously a plethora of lower court opportunities. And so I guess I think the biggest difference for me between the two, especially looking at president-judicial relationship, is that every president understands what the Supreme Court is, what the Supreme Court can be. I mean, if ever there was a president who should have cared very little about the Supreme Court, it was Harry Truman. And Harry Truman was obsessed that the Supreme Court be a place not only where his friends were, but a place where they wouldn't get in the way of his communist loyalty program, of his far-reaching executive branch enterprises. So all presidents, I think, are very attuned to what the Supreme Court can mean. But I see a real kind of down the middle, some presidents understand what the lower courts can be and create a bureaucracy well attuned to that. Reagan gets a lot of credit for that. And others leave the lower courts really to the senators to a large extent. And you know, maybe that will begin to change. Obviously, the United States Supreme Court, through their decisions, is trying to take less of a role in changing the law, reducing the Supreme Court's role in federalism and in other issues. And it may come to pass that the main focus of future presidents goes beyond the Supreme Court, goes below the Supreme Court. But I don't know. Ken?
You care to make some cross-time comparisons? I know this is, again, a little bit beyond what you did in the book, but compared to the earlier period, do you find any noticeable changes in patterns of appointment or the process of appointment?
Yeah, I think that it's an excellent question. Obviously, you're very interested in the 19th, the 18th centuries. I think what I found, and I did, it was obviously a more cursory view, but in looking at the 19th century, I think what I found that was very interesting was the involvement of a whole variety of actors in the decision-making process that no one would even think to involve today. Jefferson constantly relied on senators from South Carolina and from other southern states to create a list of really high-quality lawyers that he might consider for the U.S. Supreme Court. Today, when a president has his Supreme Court opportunity, senators are among the last to know. They find out often with the public who is, they certainly are not involved generally in generating lists. The one exception might be Bill Clinton, who did ask Ted Kennedy and Orrin Hatch who might be confirmable. But in general, actors like senators, cabinet, I found, especially at the end of the 19th century, that presidents often involved their cabinet in a very interesting way, asking them what they thought of possible Supreme Court justices, getting their feedback on who might be a worthy Chief Justice. Now, why that is difficult to say. Part of it is that the pool of potential Supreme Court justices, certainly before this century, but even a little into this century, included those from cabinet, senators, et cetera, et cetera. I mean, in the last 30 years, we haven't had one senator appointed to the U.S. Supreme Court. Actually, it goes back even further than that. I guess it goes back, back to, God, I guess Roosevelt was the last president to appoint a senator. No, I'm sorry, Burton. So that was Truman. That goes along. 1945 was the last time we had a senator appointed to the Supreme Court. A member of the cabinet, Kennedy did it, but he's really an aberration to that regard. I mean, you have to go back to Roosevelt again and Truman to find that. The last 50 years, presidents have looked to the federal courts of appeals, sometimes to the state courts, but mostly the federal courts of appeals for their pool. When you do that, there is a sense that maybe cabinet members and senators, other than from their state, don't know a lot and don't know enough to really help them. And that's when you're going to find yourself relying heavily on the Justice Department lawyers, the White House counsel lawyers, who are willing to read the endless opinions that many of these Court of Appeals judges have written, whereas in the 19th century, knowing whether a senator might be a proper Supreme Court justice, it seems to me a much more healthy enterprise to get everybody involved in that decision. And so I guess the pool that candidates come from is different, and I found that that drove the individuals that might be consulting with the president. And I think it goes without saying that that's going to change who the candidates actually are. Go ahead.
Isn't it also true that there are some consistencies across time? I mean, political considerations, that is to say, the political agenda always seems to have driven, although many presidents made mistakes when they put somebody on the court who thought they were going to do what they thought they were going to do and ended up not doing it, but they always wanted to put somebody who was ideologically compatible, or is that not
Well, I think politics has always been involved. I think there's a big debate in the literature between Lawrence Tribe and David Dinelski and others about whether ideological politics has always driven it. Tribe believes ideological politics since the beginning of time have driven it, and others disagree. But I think what I have found, and I would agree with you, is that you take a political interest and you think it's dead. You think it no longer applies, and then you look harder and harder, and then you find it again. We thought geography was really, really dead after the Nixon administration. He went to such great lengths to find a Southerner to replace Abe Fortas, and we thought after how it backfired that that was the end. That we live in a very nationalistic economy, and the notion that we have to have a justice from New Jersey or gosh, Texas isn't really covered, that's all gone. And that's what we thought, and that's what the literature seems to tell you. And then you look at the selection of Anthony Kennedy, and I think there's a very famous story where Strom Thurmond, this is the replacement for Lewis Powell, a Southerner, and Strom Thurmond went to Ronald Reagan and said, I have William Wilkins, he's my candidate, he's from South Carolina, we need a Southerner on the court, there'll be no Southerner after Lewis Powell goes, and I think you should appoint William Wilkins to the court. And the story goes that Reagan laughed, the infamous Reagan laughed and said, well, you're from South Carolina, you want William Wilkins on the court, I'm from California, Anthony Kennedy's from California, Kennedy's going to be the next justice on the court. So I don't know what to take from that except for the fact that you think a political interest is no longer applicable, and then you look and you look and you look and then you find it again. So I think the consistencies. The question is more who's involved in applying those interests and how that might result in different candidates. Because I think you'd agree that whether a senator or a member of the cabinet is trying to determine who's best on federalism for my particular issues might be very different than what a high-priced or a future high-priced Justice Department lawyer, he's not currently earning the high price, but what he's, after reviewing hundreds of opinions and countless law review articles trying to find the perfect federalism judge, how they apply those standards I think are different. But the standards, I think you're right, we look in the early 18th century, I mean certainly in the early 19th century, then we look today and we do find some parallels, that's right.
How have presidents used the press in the nomination process to float trial balloons, and then how has the press or the use of the press affected the nomination process?
Well, I think, you know, Bill Clinton is really the first president I found to use the press. The press was almost a tool in his nomination process. Obviously, the press is a dominant consideration when you're talking about selling a nominee to the public and the confirmation end of things. But when you're talking about the initial pool creation, you know, getting candidates, Clinton was among the first to hit with the idea, hey, they're going to kill this candidate. Why not float the name out? We're not committed to him yet, and let's see what the press thinks of him. And you know, this becomes a politics by trial balloon. And I think we could probably have wonderful lectures here from Bruce Babbitt and Richard Arnold and others whose names were floated to the press, were swamped by criticism, and then never to be heard from again as Bill Clinton looked for another name to leak to the press. That is really unique. I mean, I think the interesting part about this is that the press generally doesn't cover this, or as I found, when the press tries to say, well, what are the lists they're looking at, they're almost hopelessly inaccurate. And from that standpoint, I hope that the Bill Clinton experience is a lesson to not include the press heavily in the actual initial selection process. That said, it depends on how long you take. I mean, Bill Clinton took 3 months. The press is going to get a little restless. Ronald Reagan appointed Robert Bork less than 24 hours after Lewis Powell resigned. Kennedy appointed Arthur Goldberg less than 6 hours after he got noticed from Felix Frankfurter that he was resigning. So if you could hit that quickly, then you can exclude the press altogether. But you've got to be confident, and you better be right. And so whether the press will be an active agent in that stage, the initial stage of the process, Bill Clinton made it happen. It didn't always work successfully for him. I don't know whether others will look at the Clinton lesson and say anything but that, or say, I can make it work better. I don't know how we're doing on time, but John.
Conventional wisdom would have it that good decision-making processes make good decisions. As you look back over the time you studied and look at more or less flawed processes, is there a correlation between how good those justices were once they got on the court? Do bourbon drinking card playing Truman appointees, are they worse on average than?
It's a great question. And also there's obviously we're going to have to distinguish correlation from causation. Especially, I'm dealing with 28 case studies. So, but that said, I'm not sure I'm prepared to say that the bourbon drinking, card playing companions are necessarily always going to be bad justices. It didn't work out for Truman, but a lot of people say that John Kennedy's 2 appointments, Byron White and Arthur Goldberg, were fine appointments. A lot of people believe. Arthur Goldberg only served for 3 years. He left the court at Johnson's urging, but in that time period he wrote opinions that we still study today. So from that standpoint, I don't think I'm prepared, at least at this point, to say if you know the justice too well, I mean if you know the president too well, if you hang out with him, that's probably a bad sign. And the initial question you asked, what would you do? I would not want to exclude, as Nixon did, everybody I know. Nixon had been around a while. Nixon knew a lot of people. To say that no one he knew well could be on the Supreme Court is really taking most of Washington out of the vetting process. So I guess I'm not prepared to say quite yet. And the other problem, of course, is, and we didn't get into it here because it's really hard to do, what is a flaw? I mean, what is a flawed nominee? Earl Warren was and William Brennan were described by Eisenhower as the 2 biggest mistakes I ever made. A lot of people of more liberal leanings would say that they were 2 of the greatest justices ever, and in fact a panel of law professors and historians said they were 2 of the top 5 justices ever. So I think the other problem is, well, we're going to have to come to some agreement on what a flawed nominee is, and I tried to avoid that in my book. I tried to avoid saying, those were disasters because of what they did on the court. I think what we could say, however, is that if the process produces somebody who we know as soon as we see that person, did you really look at everybody? I mean, if that is what you think when you see that individual come up, I think that's where the problem is, because I think confidence in the Supreme Court, public confidence particularly, requires some sense that the great ones are at least being considered, if not occasionally getting on. thankfully, we've gotten lucky sometimes. Other times, it's not luck. Other times, they identified a great justice, and he made it on there. But I think I'm going to stop short, based on 28 case studies, of making any kinds of correlations or causations. Hey, thank you for coming. Thank you. Thank you, George. You've heard most of it before, so.